If a federal official violates your rights, is it impossible to hold them accountable? I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely. Today, we're talking with IJ attorneys Anya Bidwell and Patrick Jaicomo, leaders of IJ's Project on Immunity and Accountability. We discuss some outrageous cases of abuse by federal officials, why it's so hard to sue the feds, and what IJ is doing to clear a path to justice. This is Beyond the Brief. So before we start talking about federal officials, Anya, you recently argued at the Supreme Court about holding kind of a different sort of officials accountable. So can you talk about that and sort of explain how that relates here?
Yes, we sued a mayor, a police chief, and a special detective for having a 72-year-old grandma arrested because she petitioned to remove a city manager, their ally, from power. And that was something that they didn't like, and they wanted to send a message to everybody in Castle Hills that they shouldn't be messing with the mayor. Well, now they shouldn't be messing with Sylvia because we took that case all the way to the United States Supreme Court. And the argument was very interesting and I think left Sylvia vindicated because at the very least, you could tell that the justices understood her situation and agreed with her that it doesn't seem protective enough of the First Amendment. But if you think it's difficult to sue mayors, think again. Because if that mayor were a federal official, then you wouldn't be able to sue that federal official at all. So we're actually grateful to be able to argue to the Supreme Court that, hey, you know what, this is a mayor and let's sue him for First Amendment violations. When it comes to federal officials, you can't sue them for First Amendment retaliation. You can only sue them for very, very narrow things. And I think that's what we want to talk about today.
So what are some of the examples of, terrible things that federal officials have sort of gotten away with?
Yeah, I mean, our cup kind of runneth over in this regard. So, we could pluck any number of examples, but the one that comes to mind to me is the story of Hamdi Muhammad. And Hamdi was a teenager, a Somali refugee up in Minnesota, who was completely innocent of any crime and framed by a St. Paul police officer who happened to be cross-deputized for work on a federal task force. This woman was named Heather Waker, and she had concocted a 30-person sex trafficking ring unrelated to anything Hamdi had done, and ultimately that entire case fell apart with the Sixth Circuit shockingly deciding to affirm the few the few acquittals that came out of it and saying that after a painstaking review of the record, the story was likely fictitious. So basically the Sixth Circuit had said this woman was lying. And nevertheless, what happened to Hamdi was a girl who she didn't know very well attacked Hamdi and two of her friends with a knife. And then when the police were called, this girl ran and hid and called this officer Heather Waker because, as it turned out, this girl was a witness in the other case that would later fall apart. And to protect her witness, Heather Waker called police on the scene and lied to them and said that actually Hamdi and her friends were trying to intimidate a federal witness. And so rather than arresting the attacker, they arrested Hamdi and her friends, who, as a result of this, Hamdi spent more than 2 years in federal prison before the charges against her were ultimately dismissed and before her two friends went to trial and beat those charges. And unlike, if she had just acted as a St. Paul police officer because she was cross-deputized as a federal officer, in the dozens of lawsuits brought by all the people involved in the other case and Hamdi and her two friends, this officer, Heather Waker, was essentially spared from any accountability in any of these cases, and in fact didn't even have to sit down and sit for depositions or go through discovery, despite the fact that the courts held she was not entitled to qualified immunity. It was just because she was acting under color of federal law in their estimation that she simply couldn't be held into court at all.
Let's break down that distinction a little bit more, because I think as lawyers, we implicitly understand the state-federal distinction pretty well. But folks who are listening who maybe aren't lawyers are thinking to themselves, well, I've heard about Section 1983. I've heard about, qualified immunity. I kind of understand what the problem is. But what's the state-federal distinction, and how does that bear on the availability of a remedy under something like Section 1983?
Well, it's... So when we're talking about 1983, we have a specific cause of action against state and local officials. Because after the Civil War, state and local officials in the South were a serious problem. So Congress said, you know what, we're not liking what's happening over there, and we need to bring federal constitution in and to lift all those disputes out of there onto the federal level. So that's why Section 1983 was enacted. Federal officials at that time, they were not a problem. Nobody was worried about them getting some sort of special treatment in state courts. So you could sue federal officials in state courts, as was traditionally the case. So they left that regime there, and then they had Section 1983 for federal courts for state and local officials. So the way, though, it all developed is that today, because there is Section 1983 for state and local officials, the courts are saying there is a cause of action explicitly authorizing lawsuits. But because federal officials were never part of that framework, now the courts are saying, federal officials maybe shouldn't be sued because there isn't an explicit cause of action. And here's another kicker. We could sue them in state courts back in the day, but then Congress passed the special law, the Westfall Act, where it said we can no longer sue them in state courts. So now what you end up with is that federal officials can't be sued in state courts because of the law that Congress passed, and they can't be sued under Section 1983 or in federal courts because they're not mentioned in Section 1983. And as a result, we end up with Heather Waker, which I think actually shows like a really good example of how she is treated, federal officer versus state officer. So she was deputized in our case and was treated as a federal official, and we couldn't sue her, despite of all the horrible things that she did. But our friend Tim Phillips sued Heather Waker recently as a local officer for searching somebody without a warrant. Shocking. Heather Waker is searching somebody without a warrant. But because she was a local police officer when she was doing that search, he actually could take this to trial. And qualified immunity didn't protect her because it's obvious that you're supposed to have a warrant when you're searching somebody. So in that situation, you actually could get a remedy against Heather Waker. But when she was deputized as a federal official, you couldn't.
Well, the jury's still out on that. We're fighting that fight. But I think the point is that she kind of exemplifies this problem by being cross-deputized, because you have someone here who obviously has state power as a St. Paul police officer and obviously has some amount of federal power as a cross-deputized U.S. Marshal. And so you can kind of see in this one single persona, like how these two things might interact, how they might overlap. And the fact that if this sort of deputization immunity is allowed to prevail, how easy it would be essentially to take liability off the table, even for the state and local officers that Congress intended to extend it to through Section 1983. Because to become a deputized federal officer, all it takes is a single piece of paper that you sign, and then you're now deputized as a federal marshal, and Bob's your uncle.
So even if you have qualified immunity reforms, say, and now you no longer have qualified immunity as an obstacle, you could still deputize everybody as a federal official, and then why even bother with qualified immunity? They can't be sued, period.
Something that stands out to me about the Heather Waker situation is that one of Hamdi's friends, right, did try to sue her for the same sort of situation as a state official. And so that case was kind of going along parallel to Hamdi's case. Can you talk a little bit about how those two things interact?
Yeah, so Hamdi sued Heather Waker, and just by happenstance, the way the court in Minnesota decided it was on the basis of what's called a Bivens cause of action, which is what allows you to sue federal officers under the limited circumstances we discussed. Her friend Ifra also filed a separate lawsuit, and for similarly random circumstances, the way that was decided was on the basis of whether Heather Waker was acting under color of state law, which would open her up to liability under Section 1983. And so you had this sort of dual track situation where Hamdi's case went first to the Eighth Circuit on this question of Bivens. And the Eighth Circuit said, no, this lady doesn't get qualified immunity, but you can't sue her for her actions taken under color of federal law as this deputized task force officer persona because there's no cause of action. But they specifically said, don't worry, though, the case isn't over. It still might be possible to proceed against her under Section 1983 for actions under color of state law. And so while that was all playing out, Ifra's case was also making its way to the Eighth Circuit. Same facts. Ifra was with Hamdi during this incident. Ifra was framed alongside Hamdi. And there, the Eighth Circuit, in an opinion by the same judge, says, oh, actually, she wasn't acting under color of state law at all, basically because she was federally deputized. That sort of shrouds the rest of this stuff in like some sort of evil Midas touch. Although I guess the Midas touch is kind of evil itself. But in any case, that takes us out of...
Doubling evil.
Yeah, that takes us out of Section 1983. And so now Hamdi's case is back down to the district court. And we're kind of having this fight all over again in her case, with the idea of eventually getting these issues to the U.S. Supreme Court. Because previously, when we took Hamdi's Bivens question, whether you can sue federal officers up to the Supreme Court, the U.S. Solicitor General came in and told the court, hey, don't take this case yet. In this posture, it's not appropriate because she might be able to have a Section 1983 claim. And so we said, all right, we'll go all the way back down. We'll argue about that, and we'll come back to the Supreme Court and knock on the door one more time.
Let's unpack this Bivens issue a little bit further, because I think, again, most folks listening to this might not have heard of Bivens before. What is Bivens, and how does it answer this cause of action question that we've been talking about?
Bivens is a decision from the 1960s when the United States Supreme Court looked at whether or not it makes sense to have a federal remedy against federal officials. That statute that I told you about that prohibits suits in state courts.
The Westfall Act.
The Westfall Act. That's from 1980s. So when the court took the Bivens question, they actually did it against the background of, oh, you can sue federal officials in state courts, but does it make more sense to actually sue them under federal constitution? Justice Brennan, writing for the majority, said, yes, it does make sense to do that because we are talking about federal interests here, federal constitution. We don't want 50 different, states opining on 50 different levels of accountability for federal officers. So let's just have this one federal standard. And by the way, it's not inconsistent with common law because you could do that and you can still do that in state court. So it's all good. So that's the decision was about Fourth Amendment at that time. But then the Supreme Court also had two more cases involving Fifth Amendment and Eighth Amendment where it allowed those kinds of causes of action to proceed. But very quickly after, the court started to crack down on the Bivens remedy.
Actually, Bivens was decided in
1972.
1971.
Or 71.
Yeah. But I think
those 2 years made a big difference there, Anya.
I think for the audience, the thing to keep in mind, though, that might kind of blow their minds is the concept that you would have the Bill of Rights. You have the First Amendment. You have the Fourth Amendment. You have the Eighth Amendment. All these things that we sort of take for granted as these cherished protections that our Constitution provides us all to individuals. And essentially, without something like Bivens, what the Supreme Court is doing now is saying, yeah, you have the right to free speech or you have the right to be free from unreasonable searches and seizures, but you have no cause of action to actually enforce it. So the question that I have when you hear that is like, do I really have the right then? Then it's just a words on a piece of paper.
Right.
And that's sort of the problem with the regime that we're in right this minute, because that's kind of where we've landed.
Let me ask a brief follow-up question, because some folks, again, might be listening and thinking to themselves, well, I remember Brown versus Board of Education, right? A lot of these landmark Supreme Court cases, and this issue of Bivens didn't seem to pop up in those cases. The court didn't wrestle with whether there was a cause of action to forcibly integrate the schools, right? So folks might be thinking, why isn't that a sufficient remedy? And maybe you could talk a little bit about the prospective and retrospective relief distinction. Again, maybe we're getting a little bit too much in the weeds because we're all legal nerds here a little bit, but I feel like that might help explain a little bit why this Bivens question is so important.
Yes, because we are talking about a cause of action for damages, right? So, and that's kind of another irony, because when it comes to prospective relief, like injunction, I want the court order the government to stop doing something. For some reason, the court has no problem saying, oh, okay, there is a federal right of action under federal law. But when we're talking about damages, then the court is saying, oh, no, that's kind of like touching sovereign immunity too much. And king can do no wrong, and we don't want king to pay money. But here's the thing. Often, you can't sue for anything other than damages, right? When we're talking about excessive force cases where there's police brutality, a police officer, did something absolutely horrible to this one particular person, that person can't then go to court and say, I want to sue for injunction so that police officer can never do that again in the future. The only way that person can actually bring a suit is by saying, what happened to me was unconstitutional. You have to look back to that, and you have to give me damages. So that person is not allowed to sue for anything other than damages. So the same with Sylvia Gonzalez in the Supreme Court, the First Amendment retaliation lawsuit. She can only sue for damages, basically saying when they threw me in jail because of what I said, they violated my rights. And the only way I can do that is by suing for money damages. I think people misunderstand that often, and they look at that as like, oh, these guys want like multi-million-dollar, damages. But the reality is that's the only way we can bring these lawsuits in the first place.
Right. You can't unring the bell. You can't unarrest Sylvia. I mean, and that's true of many instances. Hamdi Muhammad's another instance. You can't take away the fact that she spent 25 months in federal custody because Heather Waker lied about her. And so that's why you end up in this damages space. The other thing that's sort of frustrating is, as Anya's explaining, is the court just uniformly treats these things differently without much explanation as to why. And on the damages side, it heaps in all sorts of things. So we talked earlier about we have qualified immunity. Now we have the cause of action issue. There are others baked in there as well. But it's particularly frustrating because qualified immunity, which applies to all of these federal, state, local, across the board, was something that the Supreme Court cooked up in a Bivens case to protect federal officials from some amount of liability. And that happened in 1982, and then they've spent the last 40 plus years basically getting rid of Bivens completely, meaning the justification for qualified immunity in that case is now gone, but beefing up qualified immunity and extending it into everything else. And so it really is this sort of topsy-turvy world where the court's sort of going out of its way to make sure that you can never, have a damages remedy. You can have prospective relief subject to a bunch of other doctrines that are problematic, like we talked about standing or mootness or whatever it might be. But when it comes to damages, the court is just going to, take every possible swipe it can for some reason.
Yeah, it sounds like the only consistent principle is the government wins, you lose.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
It's interesting, too, because when we talk about qualified immunity, people usually think about police. But as Patrick mentioned, qualified immunity was created in a case involving desk-bound bureaucrats, White House aides to President Nixon. And the question was whether they can be sued for First Amendment retaliation because they didn't renew a contract of a whistleblower. So it is a doctrine that was created to protect federal officials. But now, of course, it is irrelevant when it comes to federal officials because, frankly, federal officials can't be sued in the first place.
Well, and it sounds like this, situation that you talked about earlier with task forces and, it's a one-page form or whatever for state and local officials to become part of a task force. And so really this, blanket exists for everybody. And we've seen it in other IJ cases too, right? What else is going on with task forces?
Oh, yeah. I mean, this task force thing is something that really everybody should make themselves aware of. It's one of the sort of dirtiest secrets that goes on right now in sort of the broader concept of policing, because I think a lot of people understand, like, you have your state and local police, and that's supposed to be the sort of general police who deal with criminal stuff. And the federal government has sort of inched its way bigger and bigger and bigger and bigger over the years with the FBI and the U.S. Marshals, and there's any number of, federal police forces. But something they started doing in the 1970s, which is very quietly and insidiously spread, is the use of these task forces. And you might think, hey, I don't live in New York City or Los Angeles. There's probably not a task force where I live. But you would be so very wrong. These task forces are literally everywhere, and they're very shadowy. There's no sort of centralized information about how many exactly there are, how many state and local officials have been deputized to be members of them. That's something that we're looking into, but we haven't gotten there yet. But what we know for sure is we're dealing with probably at least 1,000 task forces nationwide, and probably tens of thousands, if not hundreds of thousands of state and local officials who are on these task forces. And the way it typically works is you'll have a core of federal officers. Maybe it'll be one FBI agent, maybe a couple, maybe it'll be a couple different federal agencies. And then you'll staff them with a whole bunch of state police and local cops and county sheriff's deputies. And they'll all be deputized with the one-page form, and now they're all transformed into federal officers. And so, for instance, the city of Pittsburgh's U.S. Attorney's Office sort of lauds the fact that there are 7 different task forces in Pittsburgh, Pennsylvania.
My goodness.
And you have Hamdi Muhammad up in Minneapolis, Minnesota, another IJ case on behalf of James King involved Grand Rapids police detective and FBI agent who are working on one of these task forces. And this same issue came up there where they said, oh, actually, even though I'm a Grand Rapids police detective with a Grand Rapids badge and a Grand Rapids gun, and I'm being paid by Grand Rapids, and I file my incident reports with Grand Rapids, and we were looking for someone wanted on a Michigan warrant for committing a Michigan crime. Nevertheless, I was actually acting under color of federal law because I signed a paper once. And that's how this works. And the federal government is now taking advantage of this and doing so aggressively. Now it's sort of recognized, certainly after recent developments from the Supreme Court that have really, really restricted Bivens to almost nothing, that, wow, this is actually, we're very well positioned now to continue with this. And now these guys and girls will be, untouchable because they'll be federal guys and girls instead of state ones.
All of this sounds really bleak, right? Is there any reason to be optimistic here?
First of all, there is a simple solution. But for some reason, it's so hard for Congress to do anything about it. We have Section 1983, as we talked about before, and it includes state and local officials. All they need to do is add 2 words, and include federal officials in there too. That's it. Just like that.
Yeah, and we've seen commentary from various places where, litigants and judges have pointed out, hey, at this point it's starting to smack of double dealing. This is something that Judge Willett in the Fifth Circuit has said. You have Congress saying, hey, all the state and local officials, they can be sued, but at least tacitly saying, actually, the federal ones can't.
Right.
And so you're kind of scratching your head because you're thinking, I thought this was the federal constitution, that they should at least be liable under that. And now we live in the situation where, federal police receive more protections than state police.
And I don't know why it's not registering with Republicans. We're having a really difficult time convincing Republicans to amend Section 1983. You'd think they would be the first ones out there asking for it, right? Because we are talking about FBI, we're talking about IRS, we're talking about Bureau of Land Management, but yet Republicans are nowhere to be seen on this. Just add 2 to 5 words to that bill to include federal officials in there, and this double dealing is going to go away. And then we will be fighting qualified immunity, and it still will be extremely difficult to sue government officials, but at least you're not going to have this 2-track system of accountability. The second way to go about it is to ask the Supreme Court to be more generous in its interpretation of Bivens. But frankly, I sympathize with the Supreme Court much more than I sympathize with Congress on this, because a solution is right there staring them in the eye, and they are refusing to do anything about it.
I would be happy for either solution, but I'm much less sympathetic to the court. And the reason that I feel that way is, I mean, fundamentally, the Bill of Rights is this anti-majoritarian document. It's something that the founders put in place because they said, hey, democracy and majoritarian rule, that's kind of the principle, the background principle for our republic. But some rights we think are so important that we cannot let the majority dictate whether you can have those rights. And we are going to put those in the Bill of Rights, the first 10 amendments to the Constitution. And so for the Supreme Court to then turn around and say, yes, we recognize the very important anti-majoritarian rights, but the only way you can enforce them is if the majoritarian branch of your government, Congress, passes a law saying you can. And that just strikes me as just fundamentally bizarre and kind of inconsistent with, Marbury versus Madison among dozens or hundreds of other Supreme Court cases over the last century or two.
There is also another solution, and that goes back to the Westfall Act, right? That thing where Congress says, oh, you can't sue federal officials in state courts. So another potential way around this is to open up open up state courts to these kinds of claims. And there are states like California that have what we call Baby 1983 civil rights acts, where California specifically allows not only suits under state constitution, but also suits under federal constitution. And if the Westfall Act is not a barrier, then you actually could sue a federal official in state court. And then I actually think we're going to go back to the Bivens world where Brennan was saying, oh, I don't like how you sue federal officials in state courts. Maybe we should bring them all back into the federal system.
It's one big circle, isn't it?
Always.
So between Bivens and qualified immunity, there are all sorts of doctrines that make litigating these cases really hard. I think you guys know that firsthand, having litigated a lot of them. I've litigated a few of these cases myself. Without places like IJ, how would these cases really be litigated? Because so many private attorneys are relying on contingency fees. But it's really hard to agree to take up a case on contingency when you know there are so many barriers standing between you and victory.
That's why private attorneys out there, where's the camera? Where do I look? Private attorneys out there, if you are listening right now, the Project on Immunity Accountability that Patrick and I run, we are happy to partner with you guys and help to get rid of these doctrines and then give the case back to you so you can go to trial and get some sort of accountability for your clients. But it is extremely difficult. And that's why we need public interest law firms like IJ, like MacArthur, like ACLU, who are willing to take on these kinds of fights. And even if it's a losing battle, we still want to take it on and take it all the way to the Supreme Court so the Supreme Court evaluates and reevaluates those kind of things.
Yeah, there's no question that, we have these doctrines and they have all these rules and we, parse them and say this is silly, this is ridiculous. We talk about it here. But to this point, there are a lot of unseen consequences to this. And one of them is if this happens to you, even if it's a state official, you're going to have a hard time finding a lawyer. These are hard cases. Qualified immunity makes this very difficult. Like you said, oftentimes these are contingency fee cases. So even if that weren't difficult, the merits of constitutional claims are difficult. And you're talking about years of legal work before a potential payoff. But add on top of that, this federal immunity that comes through the restriction or decimation of Bivens. And you're just not going to be able to find these attorneys at all. And so what that effectively does is really undercounts the problem because there are hundreds of instances of abuse taking place probably every day in this country, given that we have hundreds of millions of people living here. And many of those will just get swept right under the rug. Nothing will ever happen. The lawsuit will never be filed because the lawyer will never be found. We won't even get to discuss how qualified immunity thwarted it or anything like that. These are just things that will go, to be forgotten completely.
Yeah, so listeners might be thinking, this is an impossible fight, but it's not. You were just at the Supreme Court arguing these things. Patrick, you were at the Supreme Court not too long ago arguing these things, and IJ's really at the tip of the spear, kind of making progress here. So what does some of that progress look like?
The progress is about state legislatures, about Congress, about the United States Supreme Court, and about state Supreme Courts. It's all inclusive approach, and we are hitting every single one of those things. We are lobbying in state legislatures, we are lobbying in Congress, we are also bringing cases in state courts, we're bringing cases in federal courts, and we're just trying to put pressure in all these various environments, hoping that one day something is gonna give, and we'll continue putting more and more and more pressure until we achieve positive outcome.
Yeah, I think another thing to keep in mind is that many of these doctrines have had, half a century or more to sort of metastasize to the point where they are now taking our rights away left and right. And so when we started this project at IJ, we knew this was a project that was focused on decades, not on years or months. And so, we have been laying this groundwork now for 5 years, and we're ready to stay in this fight as long as it takes. And, ultimately, we feel very confident that we'll win because we know we're right. We have the Constitution. We can go look at it in the National Archives, and we're going to be able to enforce it eventually. It's just a matter of fighting as long as it takes to make that happen.
And that kind of reminds me of another thing that we're doing, and it's talking to law students and even young people before they go to law school, because when we kind of explain our vision to them and then they, become lawyers and they become judges, then they can make a difference. So because it's a long-term project, we are investing in many different generations to come.
Thanks so much for coming in today, guys.
Thanks for having us.
Thank you.
Thanks again for watching today's episode. We got a lot of great comments on our last episode, so let's read a few. @Morthrax writes, please fight this one to the Supreme Court. We need our Bill of Rights to actually work. I completely agree, and we're working on it. @Pumpkin3282 writes, if you fence in your 100-acre property with no trespassing signs and lock your gates, can the government still search without a warrant? Well, under the Fourth Amendment, the Supreme Court says yes, they can. Fortunately, though, state constitutions can provide more protections. In fact, just a couple of weeks after our last episode aired, the Tennessee Court of Appeals held, in a case IJ is litigating, that the Tennessee Constitution requires state officials to get a warrant in order to search land a person has put to actual use, whether by fencing, farming, or otherwise. @Kevin Grierson writes, Area 51 is an open area. We should be able to wander on the property, no? I tell you what, Kevin, you try first and then get back to me. @Ethan Mackay writes, I want to know how this applies to rural homes. Say you have a home sitting on 5, 10, 20, or 30 acres and you live on the property. How does the open field law apply to this situation? How is curtilage determined in this situation? Well, the open fields doctrine applies to all land outside the curtilage. According to the Supreme Court, whether land qualifies as curtilage depends on 4 factors. First, the land's proximity to the home. Second, whether the land is within the same enclosure or fenced area as the home. Third, whether the land is used for the same domestic purposes as the home. And fourth, any steps taken to preserve privacy. While those factors are pretty squishy in practice, your curtilage is basically your yard. So if you have a house in the middle of a 30-acre farm, the yard immediately around the house might be protected. But the vast majority of that 30-acre parcel is totally open to warrantless searches. @SeekingTruth writes, how high can a craft hover above your house? How high do your vertical property rights go? Well, the traditional common law rule is that you own your airspace to the heavens. But every state has adapted that rule in its own way, so it's hard to give a blanket nationwide answer today. For what it's worth, though, FAA regulations allow commercial aircraft to fly over your property as long as they don't fall below 500 feet in altitude. @Cranial Commando writes, let's say that someone owns 1,000 acres of land and another person sneaks on and plants illegal drugs. If the police were to find the plants, could the landowner be held liable? Well, we can't answer this for every jurisdiction, but I don't know of any strict liability drug crimes except perhaps in cars, certainly not for that quantity. If in your hypothetical that person has no knowledge, then they did not commit a crime and they're probably fine. @Robert Woodruff writes, something I don't understand, even with the open fields doctrine, is how can they take his camera? If he had a tractor out there, could they take that? How about if he parked his motorcycle while working in his field? Could Do they just come and take it? Can they take anything sitting on his property? Well, technically, the open fields doctrine doesn't allow warrantless seizures of property. Every time the Supreme Court has talked about it, the cases have been about searches, not seizures. And in 2022, the Sixth Circuit Court of Appeals even held that it was clearly established for purposes of qualified immunity that the open fields doctrine did not justify the warrantless seizure of cattle from a field. But despite all that, government officials all over the country tried to push the open fields doctrine to its limits. And that's how we get situations like what a Virginia client experienced when they invaded his land and took his camera. If you give them an inch, they'll take a mile. Thanks again for watching today's episode, and be sure to tune in next time.